Hello, and today we're having a look at causation in criminal law, and we're looking at the idea of Novus Actus Interveniens, that they are they are new intervening acts which step in and they excuse the defendant of all liability, because the defendant's act suddenly is no longer the operating and substantial cause of death. There is a new act. We've already looked at acts of God, natural intervention, and third-party intervention. The third type now we need to look at is medical interventions. Now, this doesn't usually count as third-party intervention, as you might think, prima facie. And this is because medics are on a duty to give the best treatment available to patients, and therefore they're not working in a free and voluntary manner. So how do we go about working out whether a medical intervention counts as a Novus Actus Intervenien? Well, basically, there's two questions you have to ask. The first one is, how negligent or wrongful was the treatment? In cases like Jordan, you'll see it's so wrongful that it does break the chain of causation. Otherwise, it doesn't really. And the second question to ask is, was the original wound within which they came to the medical attention for still an operating and substantial cause? Now, we're going to understand this by looking at a few cases. So, to begin with, R and Jordan, 1956. Now, the defendant and the victim are members of the US Air Force. They have a fight in a cafe, and the victim is stabbed by the defendant. Victim is then taken to hospital, and a stab wound is found in two places. And he's recovering, he's better till the hospital give him the wrong antibiotic, one that he's in fact allergic to. There is also fluid in his lungs, I believe it is, or it was just, there was other issues in giving him treatment. Now, what he essentially died of, the defendant, was not the stab wounds. He died of pneumonia, which was caused because of this wrongful treatment. But the defendant is still pursued by the prosecution and convicted of murder. So what happens at this case? Well, basically, they say the medical treatment was palpably wrong. It was clear that the death was caused by pneumonia, nothing to do with the wounds. And therefore, they said it broke the chain of causation. Now, this case hasn't been applied or followed by other cases. And in fact, in the next case we're going to look at, Aaron Smith, it's said to be confined to his own facts, because to find another case where medical treatment it's so palpably wrong, as they say, is given, is quite rare. So you can imagine it hasn't been applied, but it's good for showing where medical intervention does count as a Novus Actus Intervenien. So the next case, Aaron Smith, where they describe Jordan as being particular to his own facts. There was a barrack room fight in the military. The victim was stabbed twice, and his friend attempted to carry him to the medical center, but ends up tripping twice, and obviously the guy gets hurt more. At the medical center, they put him on a ventilator as they don't have blood for the blood transfusion. So it's held that at the time of the death, the original wound was still a substantial and operative cause. Because despite the failure to give the blood transfusion, because if they had given the blood transfusion, the life chance of survival would only be increased, I think, by 25%, or it's a very low percentage like that. So therefore, the original cause was still the defendant's actions, and the medical intervention of forgetting to have the blood ready for blood transfusion was not an operating and substantial cause. And the quotation goes, only if the second cause is so overwhelming as to make the original wound merely a part of history can it be said that it does not flow from the wound. So you can see the reluctance to charge doctors. They don't want it to become into a doctor trial. And also, when you convict doctors, you're convicting them usually on negligence. And that's more for civil law to deal with in the eye of the law lords than for criminal law to deal with. Then the next cases are Ann Malcharek and R. and Steele, 1981. The victims of assault, they're put on a life support machine, and then sometime later the doctor switches the machine off. So the victim dies. The defendant is charged with murder, but the defendant says, hold on, you turn the life machine off, you are responsible, you are a Novus Actus Intervenien. but it was held that life support machine did not break the chain of causation. Doctors act with their legal duty to give the best treatment available. If life support is no longer a beneficial treatment, then switching it off is part of the treatment, and so there's that aspect to it. And also another way of justifying the judgment is that the doctor's conduct as a whole you have to look at, because they first intervene to come and save the victim's life, and later they take away the assistance. It's not their fault. It is the defendant's fault. But the interesting point to note is if an intruder came and turned off the life support machine, as we saw with Airedale and NHS Trust with the Bland case, when they came and they turned an intruder or a family member comes, then there is a Novus Actus Intervenien, because there's no such duty over there and they are acting freely. Doctors are not acting freely. This is the key point. Then we get to the whole case that we started in my introduction video about, which was R in Cheshire, 1991. The victim was shot in a fish and chip shop. The wound was so serious that the patient required a tracheotomy. The victim had surgery and he seemed to be improving until he died. One expert said it was due to a heart attack, and another one said it was due to a failure to recognize why there was a problem. So you can see that there's issues as in with the causation of death, what actually caused the death. And the defendant saying, well, I think it's more to do with the hospital treatment than the me shooting him. And it was held here that only in extraordinary and unusual cases, such as Jordan, that medical interventions make such a difference, where it is clear that but for the doctor's actions, they wouldn't have died. And accidents, it was accepted, regularly happen even at the best run hospital. So you can see an even more defensive attitude is coming along towards doctors. But the key point to remember is you're looking at whether the doctor acted freely and in an informed manner, and also what was the factual causation that goes along with it. In Jordan, it was clear that it was to do with pneumonia, not the stab wounds. In these other cases, it's not so clear. Anyway, I hope this helps. Thank you for watching.